We go. So at this point in time now, I'm going to introduce the session, and we're going to be talking about wills and estate planning as already indicated. We will have a presentation from Sara Hawkins of the Public Legal Information Association of Newfoundland and Labrador, known by an acronym called PLIAN. And we're going to talk about the importance of having a will, when you should update it, the pitfalls to avoid, what you should include in your will, the role of witnesses, what to keep in mind about beneficiaries, and considerations for matrimonial property, always a big consideration, that one. Joint bank accounts, need for lawyers, and so on, with everything that pertains to planning for that particular time in your life. We'll also talk about power of attorney and enduring power of attorney. So a very busy evening for sure. So as I already indicated, our presenter for tonight is Sara Hawkins, and she is an access to justice coordinator with the Public Legal Information Association of Newfoundland and Labrador. And she has over 16 plus years as a paralegal and has worked with private firms, legal aid, the courts, and nonprofits. She has worked with all aspects of the law, but has a passion for us older folks who need help navigating the legal aspects of aging. So when not at work, you will see Sara volunteering as a first responder with St. John Ambulance, and you can usually find her at any of the big events around this city, and I guess elsewhere across the island too, Sara. So at this point in time, I turn the presentation over to you, Sara, and welcome to your presentation.
Oh, that worked. I'm always impressed when it works.
For sure.
Yes. Well, thank you, everybody. And you'll have to excuse me. I've been battling a really bad asthma flare for the past little while, so the voice comes and goes. But I'll do my best to get this here for you today. So today is just a high-level overview introduction to wills and legal planning. And what we're going to talk about is what is PLIAN and what do we offer. We'll talk about wills and estates. So what exactly is that? We'll talk about enduring powers of attorney, and then we'll end off with advanced health care directives. If you have any questions at all, again, just put them in the chat and I'll try to answer them probably at the end. So the Public Legal Information Association Newfoundland and Labrador, we've been around since 1984. And what our mandate is and what we do is to provide legal services and information to everybody in this province. So what we do offer is a legal information line. We do plain language legal publications and presentations. So we take the legalese out of legal documents. So we'll take a document and we'll sit down and we'll make it so that people like myself can understand it. We provide a whole host of online resources as well. So our website is very, very comprehensive. And we also have some project work as well. I get to travel all across Newfoundland and Labrador and deliver presentations, not only on wills and estates, but on pretty much any aspect of the law. And I always say, any excuse to get outside of St. John's, I am there and ready to go. So I love to travel across our province. So our most popular thing that we deal with is our legal information line and our lawyer referral service. So on our slide here, you can see our phone numbers and our email address. You can call us Monday to Friday between 8:30 and 4 and ask us any question that you may have about any aspect of the law. We can't give you advice, but we can give you a lot of information as well. So we provide it to anybody all across this province and even outside of the province as well. We can also do in-person appointments if you wanted to meet with us and have a chat. We also have our lawyer referral service. So that is a consultation with a practicing lawyer. It's a 30-minute consultation for $40. So what this does is it's summary legal advice. What that is that there's no legal work done. They're not going to draft any documents for you, but they're going to give you some really good legal advice and let you know what your best option is in a legal issue that you might have. You can hire the lawyer after the 30 minutes if you like. You don't have to, and there's no obligation for the lawyer to take on your case. That's a discussion between you and the lawyer, and everything you discuss is confidential between the two of them. Our next thing that we do offer as well is our legal rights for newcomers. So that provides support for anybody new to Newfoundland and Labrador and anybody new to Canada. So people like immigrants, refugees, students, temporary foreign workers, and the primary focus is on everyday legal problems and understanding their legal rights. The highest demand that they do have is labor employment right now and residential tenancies. So those are the two big things that we help out our newcomers with. And then we have our Journey Project. So our Journey Project is a partnership between PLIAN and Sexual Violence NL, and it's funded by Justice Canada with support from the Department of Justice and Public Safety. And what this does is it provides outreach and training of justice personnel and frontline services. And it also provides free legal advice for survivors of any form of sexual violence, including sexual assault, harassment, distribution of intimate images without consent, or intimate partner violence, including physical, sexual, financial is a big one that we hear of as well, and emotional and psychological abuse in the context of a partner relationship. And you can contact them through us. So the big question that I do get whenever I do presentations or people call us is, what is information as opposed to legal advice? So legal information, what I do is I explain the law and the legal system in very general terms. So I can say, generally speaking, usually this happens, best practices are, etc. It's not tailored to a specific case or your individual circumstance. And I can tell you every single option that you can choose, but I can't tell you which one is the best one for you. And I can also sit down and go through forms with you to make sure they're filled out correctly, but I can't give you the words to put in there. So I can tell you which boxes to click or what boxes to fill out, but I can't tell you the exact words that you need to go in those boxes. So legal advice, that applies the law, including the statutes and case law and legal principles to whatever situation, and it will give you the best option. So I can say, hey, you have option A, you have option B, you have option C. That's legal information. Legal advice, which I'm not allowed to give, would be, but you need to take option C because that is your best option. So that's, you know, a big difference between our legal information versus legal advice. So what is a will? Why is it important? So there are some requirements when it comes to having a will and writing a will. They are under what's called our Wills Act. And wills here in Newfoundland and Labrador have to be in writing. So it has to be a hard copy printed off of a computer or written by your own hand. You have to be 17 years of age to write a will. If your will is not handwritten, so it's printed off of a computer, you typed it up and printed it, it has to be signed in front of two people who are over the age of 19, who are not going to benefit from your will in any way, shape, or form. Those witnesses have to be present at the time you sign the will. However, they don't need to read your will. So they're just looking at you and looking at you signing your name. And again, over the age of 19 and independent from you and your beneficiaries of the will. You have to be free from pressure. So that means that I'm not allowed to go and sit next to my mom and force my mom to put things in her will or make sure that she leaves my brother out of the will. Okay, so I'm not allowed to pressure anybody. So you have to make the will from your own mind and what you want. And you have to have legal capacity when making a will. So legal capacity, what that means is that it's fluid. So it can change from day to day and moment to moment. When we're talking about capacity for making a will, what we're looking for is, I understand I'm writing a will. I understand what I own and who I'm giving it to. And I understand that the people who I'm giving the items to and who potentially I am excluding in my will. So I know what I know I want to write a will, I know what I own, and I know who I'm giving it to. So that's how we measure capacity when it comes to making a will. What this means is that if you're diagnosed with dementia or Alzheimer's, as long as you know that you want to write a will, you know what you own, and you know who you're giving it to, you can make a will. So the important parts of the will has to be dated. Super important. Your will has to be dated. If your will is not dated, it's not considered valid and you're not allowed to use it. Okay. The executor, you have to name an executor, and we'll talk about executors a little later. This is the person that's going to handle all your money, your assets according to your will, deal with all of the things that needs to happen for tying up your estate. Those two things have to be in your will. And then the biggest part and probably the hardest part to try to figure out is the gifts. So who is getting what? You know, are they legacy items that you want to give? Is it property? Is it cash? What's happening to your stuff? And that's the main reason why people write a will, is because they want to make sure that the people that gets their stuff is the people that they want to have their things. So executors, who are they? They can be anybody as long as they're over the age of 19. They can be a son, a spouse, a daughter, a friend, whoever. Your executor can be anybody. You can have co-executors, so you can have more than one person be your executor as well. And it's always good to have a substitute executor. So what that means is, say, for example, I appoint my spouse to be my executor, but if they're not able to do it, I'm going to appoint somebody else to take their place. Your executor is your legal representative. So they're going to handle all of the legal, financial, anything that they need to do. They're going to have to file final income taxes, contact Newfoundland Power, the cable company, all of those things. They're going to have to clue up your business if you have one. And if somebody decides to contest your will, your executor is going to be the person that's going to represent your estate in court. Executors do have to act in good faith. So what that means is that they have to ensure that you're not going to lose money unnecessarily. So for example, if you have a home that you said you wanted to sell in your will, and they decided to, the home is worth about $500,000, but I don't want to have to deal with trying to sell it and somebody's going to offer me $200,000. That's not acting in good faith. That's just trying to get things done as quick as possible and not doing the best for your estate. So when you're thinking about choosing an executor, you want to choose somebody that you trust and somebody that you know is going to carry out your wishes to the best of their ability and who's going to try to get the most for your estate if they do have to sell any assets for you. Some logical and practical considerations is, where does this person live? Are they going to have to travel to Newfoundland in order to clue up some things of your estate? That's something you may want to consider. Their professional background. Are they going to be able to understand what it is that they need to do? And then the time and capacity to spend on executors' duties. Executors can be, being an executor can be very, very time consuming. It can be very overwhelming. So you want to make sure that the person you choose is going to be able to take care of that and do all the things that needs to happen in order to be your executor. So you can hire a professional to help manage your estate, like a lawyer or an accountant or financial advisor, all of those things. It's peace of mind, it's great, but it costs money. So if you say appoint a lawyer to be an executor, know that they're going to get their fees paid before they pay out your estate. And another best practice we do kind of see is directing your executor to provide an accounting. So you can certainly say in your will that you want your executor to provide a statement of account every month, every quarter, whatever you like, to your family, just so that they know that the executor is doing the things that they need to do above board and not taking the money and going to Florida with it or whatever they'd like to do. Some other important considerations: a will needs to be clear and understandable language. Gone are the days of the very confusing legalese. Most of the wills that I've seen in the past 3 to 4 years, there's a big trend into taking out all of the therefores, thous, all of the old language that has been in wills for a very long time. So, you know, your will can be very simple and very clear. So my name is Sara Hawkins. I live in St. John's, Newfoundland. This is my will. I appoint John Doe to be my executor. If John's not able to do it, I appoint Sally. And here's what I want done with my stuff. X, Y, Z. So gone is a legal language. We're trying to make it clear as possible. The other thing that we talk about when we're talking about clear, understandable language is there another possible interpretation that could nullify your gift? So the example here is really funny. If I put in my will, I give my money to my friends. Well, we don't know who our friends are, but guaranteed you're going to have hundreds of people coming up and saying, hey, I'm your friend, I'm your friend. So you want to name those people by name, okay? Even if you say, you know, I want to give this to my sister, name your sister, name your brother, name your spouse even. Name everybody in that will, okay? Really important to use names. Be specific to clearly identify what you're giving away and who. So for example, I give one of my cars to my brother, Jack. Okay, well, which car, right? Which brother, Jack? Do you have another brother? Who knows? The better example would be I give my 2009 Hyundai Elantra to my brother, Jack White, of the town of Makkovik in Newfoundland and Labrador. That makes it more clear, so we know exactly what we're giving and to who, and it makes it much easier for your executor, and there's less likely to be a fight about who's getting what when you specifically state it. Your contents of the will. So your personal property, anything personal that you want to give. The biggest examples that I see here are things like artwork, antiques, jewelry. The list can go on, and you can be very, very broad with this. We're very specific. Your real estate and your land, just think about what it is you want to do with that. Do you want to sell it and split the assets among your beneficiaries? Do you want that to be kept in the family? So just think about who it is and how many people are going to receive that real estate and how it is going to be split, if it's going to be split, or if you want to keep it in the family. The biggest example I'll give here is that we have a piece of land that is going to be willed to me. I know that. We've had the discussion because it's been in my family for centuries. And I go out there a lot. Like it's a place that I go to, a Fairbesh. My brother, on the other hand, has no interest in this land, hasn't been out there since he's been a child. So we've had the discussion with my parents that I'm going to get the land. and I know that, and that's great. But my brother's going to get something else instead to kind of bump up the value of what I'm getting and what he's getting. But the stipulation is that I'm not allowed to sell that land. That land is going to stay in the family, and that's what we're really looking for here. So just think about that when you're talking about, you know, your real estate. Or do you just want to sell it and split the money? That's fine too. Money versus percentage of an estate. What I will say about that is that if you are considering giving specific named amounts of money, so I'm going to give $10,000 to Sally and $15,000 to Joe, that's wonderful. But if there's not $10,000 put aside for Sally and 15 put aside for Joe, or however I had that, then they're going to get nothing, okay? Because that money is not there. So if you're going to put set amounts of money, you want to make sure that that money is set aside. The more common thing I see is I'm going to give 15% to John and 20% to Sally. That's normally what I see, or 5%, whatever the math is that you want, that's okay as well. The residuary clause, this is one of the most important clauses under the will. This is the I give everything else to. Okay, so anything that's not specifically stated in your will would go in this residuary clause. So it can be expressed as a percentage of an estate. So I give all of my remaining assets. So I give everything else to my sister, Jackie Burns of the town of Twillingate, Newfoundland and Labrador. Or I give all of my remaining assets or everything left over to the following: 25% to the SPCA, 25% to St. John Ambulance, 25% to the church, and 25% to somebody else. Okay, so you can do that as well. The reason why we have what's called the residuary clause to deal with everything else is that if there's something not disposed of in a will or not given away in a will, it'll fall to the Intestate Succession Act. And what that means is that it's divided among family members according to a formula in the act. And that formula might not be the way that you want your things split up. So really important to have this. I give everything else to. Some special considerations when it comes to the will is your matrimonial property. So under the Family Law Act, the Family Relief Act, what it does is it allows the spouse to apply to the court for 1/2 of the shared assets when a spouse dies. So if there is no will and my spouse dies, I can apply to the court and it will be granted that I get 1/2 of all of his assets. Okay, the other half will be split among his surviving children. What that means is that my spouse can't write me out of my will. He can't write me out of the will, okay? Because I am able to apply to the court to get 1/2 of the shared assets, and I will be granted that. This only applies to married spouses though. And what I mean by married, what the definition of spouse is you have the ring on the finger, you have the marriage certificate, either a civil service or a church service, okay? So you have a certificate of marriage. You're not living common law. Common law is not recognized here in Newfoundland and Labrador. And I will say that one more time. Common law is not recognized here in Newfoundland and Labrador when it comes to wills and powers of attorney and guardianship and all of the estate things, okay? Doesn't apply in family law either. Matrimonial home. So if you are married and own your own home, the spouse is going to receive title to that property in the event of death. That's normal, except in common law. Common law, you are not entitled to receive anything from the estate unless you are written in the will. So my biggest takeaway that I have from this slide is if you are living common law, you better get your will done to provide for your common law partner. That's really, really important, because otherwise what will happen is that if you don't have a will and you pass away, your common law spouse is not entitled to anything. Your common law partner is not entitled to anything. So then it'll go to the Intestate Succession Act, which would mean that your children would get everything, which is great, wonderful for them. But if you're living in a home with your common law partner, your common
Sarah, I think we have, okay. We're
some
back
questions.
on?
I'm sure we have
Okay.
questions.
Yeah, no, we're back on now. For a second there, you just froze. Okay,
Oh,
everything froze up.
okay.
So folks, again, if you don't have your screen turned off, can you please turn your screen off? That'll cut down any impact on the bandwidth, please.
Okay, we back
Colleen,
on?
I think we can turn people's screens off too by the video.
Okay, I'll do that, Sharon.
Okay. Okay.
Okay, I've got mine off as well, but you can still hear me, so all good. So if you're joint bank accounts, if your spouse dies and you have a joint bank account, nothing's needed for you to access that account. So what that means is if my husband dies, I can still continue on with that bank account. That's okay. Wonderful. What we are seeing, and one of the trends that I am seeing, is that if I have a joint bank account with my mom to help her with her daily banking, or my dad, or some other elderly person, what the trend is that on death of that person, the bank's going to freeze that account until they determine where that money needs to go. So does that money need to go to an estate account? All of those things. So you may have to get probate done in order to access that bank account, even if your name was on it. What banks are looking at? They're looking at intention. So intention of a joint bank account with my spouse is that I'm putting money in, he's putting money in, we're both putting money out. A joint bank account with with my mom and me as an adult, she's putting money in, she's taking money out. I'm just there helping with the day-to-day. Okay, I'm not entitled to that money. I'm not using that for my everyday things. What they're trying to prevent is they're trying to prevent me from, okay, now mom's dead. My brother is entitled to some of this money. They're trying to prevent me from going in and cleaning out the bank account. Okay, so they would probably freeze it. That's the trend we're seeing now when it comes to that. Some other considerations that's kind of important. If you have minor children, so children under the age of 19, or you have adult children with disabilities or any other dependents, you can list instructions in the will, and they, generally speaking, a court will uphold that. The person that you appoint would have to apply to the court, especially in the case of minor children. However, a court places a lot of weight on what I would say in my will. Okay, they look at what's in the best interest of the child. Person that was named in the guardian as guardian of the children lived out of province, and the children had a really good family support system here in Newfoundland. So the court felt it was in the best interest of the children to stay here in Newfoundland. That's the only time I've ever seen it. I've seen it once in, I know Sharon said I was at this 16 years. It's now 18 years. So I've been at this now a while. Marriage. So if I have a will and I get married, my will is void unless steps are made to ensure it's still valid. So that means I have to do an amendment to my will in order to make sure my will is still valid. So my will is null and void when I get married. However, if I get divorced or I separate, my will is still varied or still valid. So what I want to say here is that when you have a big life change, you might want to take out your will to see if the things are still valid and ready to go. So, I know that when my kids turn 19, I'm going to have to change my will because I won't need guardians for them anymore. If I get divorced, I'm going to have to change my will because I don't want the ex to get any of my stuff. If a beneficiary dies, the gift may be canceled and it would go to what's called a residual estate, unless there's specific provision in the will. So most commonly what I see, say for example, my parents have a will. And again, I don't really know what's in it. I don't know what's happening except for that piece of land I discussed earlier. What normally I will see is I want my property to be split equally among my 2 children. However, if one child dies, I want their share to go to my grandchildren. That's the most common one that I do see. Otherwise, what'll happen is that it will go to what's called the rest and residue of the estate. So it'll be split as the everything else. Okay, so you can always put substitutes in there as well. Some other things you might want to consider when it comes to estate planning, digital assets. I'm not going to spend a lot of time on this because I don't know a lot about it. I am not high up on the tech. But when we're talking about our estate, we need to consider, how do we access our online banking? Who accesses our online banking? If we have cryptocurrency, how does that work? How do we close our email accounts? How do we close our social media? Do I have any digital artwork or any programming that I've done, like intellectual property? Did I create a game? Like, what's going to happen with all of those things? Those are the things that you kind of want to consider. And when it comes to social media, you want to make sure that there might be a list of what social media accounts I have, so that your executor can go and contact them and close out those accounts. Really important to close out those accounts on death, only because it's really easy if they're not closed and they're just dormant for hackers to pretend to be the deceased person. I've seen that happen more than once. And not only is it a bit upsetting for, the loved ones left behind, it's a really easy way for fraud. So we want to make sure that we know where those social media accounts are so that we can contact them and get them closed. And each social media thing has a certain way on how they close them. I'm not familiar with it. So you would have to, that's some of the digging that your executor would have to do. Some common misconceptions. So there's no reading of a will unless it's put into the will or the executor decides to do so. You see this on American TV. Oh, sorry. You see this on American TV all the time. They're coming from the funeral and they go straight to the lawyer's office to open up the will and read it. Doesn't happen here. It's not necessary. You don't have to have a formal reading of the will. In fact, your executor is required to keep the will private, including from family members. Okay, they can disclose what's in the will, but there's no requirement for them to disclose it. It's supposed to be private. Common law relationships. As I said before, it doesn't mean you're entitled to anything under the law, no matter how long the relationship was. You're not entitled to anything under the law here in Newfoundland and Labrador. You do not need a justice of the peace, a lawyer, or a notary to witness your will or be part of your will in any way, shape, or form. Your will is considered valid if it's dated, has an executor named, and it's witnessed by 2 people who are over the age of 19 who aren't going to benefit from your will. Okay. And a diagnosis of dementia or Alzheimer's doesn't mean you can't make a will. As I said before, what we're looking for is, I know I want to make a will, I know what I own, and I know who I'm giving it to. So why have one? It's important, peace of mind for you. It puts you in the driver's seat. It makes you figure out what it is that you want to happen. Okay, so otherwise, if you don't have a will, what'll happen is that you'll have to go to what's called the Intestate Succession Act, and that's going to have a formula that splits up your assets in a way that you might not want. What that normally looks like is this. First, it goes to spouse and children. If no spouse, then children only. If no children, then siblings. If no siblings, then parents. If no parents, then aunts and uncles. If no aunts and uncles, then cousins. If no cousins, there's going to be cousins, right? So it's going to try and find a way if you have the Intestate Succession Act. So, but that might not be the people that you want to have your things or deal with your estate. So having a will puts you in the driver's seat. It puts you in control of what you want done, after what your wishes are and what you want done. So it gives you peace of mind. It's going to help you maximize your estate's financial wealth, because having a will makes it so much easier and so much cheaper to deal with your estate. It's going to take stress away from your family and friends, because now they know what you want, instead of, oh, I don't know what mom wanted. I didn't know what dad wanted. Okay. And it can prevent fights in your family because it's specifically stated, you know, well, I want so-and-so to have my earrings. And it allows you to put who you want to handle your financial affairs, and it allows you to choose how your financial affairs are handled. So it makes sure that your wishes are going to be followed. So if you don't have a will, somebody's going to have to apply for letters of administration. This is a court process. It's quite lengthy and it takes a lot of money and it's a lot of forms and it can be quite difficult to do. Your estate is going to be divided as per your act and not your wishes. And you have to find out every single person who is potentially entitled to your estate. And that can take a lot of time and a lot of money, and it is quite expensive. As opposed to what's called probate. Probate is a court process of making sure that the will is valid and legal. Again, it's a little bit of forms, but it's not as expensive as letters of administration because there's no real extra that you need to do with it. Whereas with letters of administration, there's a lot of extra. So what I'm going to do now is I'm just going to take a look at the chat and see if there are any questions and answer those. Okay. So I'm going to answer these in order here now. Will this be recorded? Yes, it's being recorded right now. Do wills have to be prepared by a lawyer to be legal? No, they do not. Like I said, in order to be legal, they have to be dated, they have to be signed, they have to be witnessed, you have to have an executor. 4 things to make your will legal. Can your lawyer be your executor? They can, but they're going to cost you a lot of money because they charge by the hour to be an executor. If somebody's mental health status changes, can changes be made knowing that is what they want? Leslie, I'm not really sure what you mean by that. The only person that can change their will is the person who wrote the will. Okay, so if their mental status has changed and they wanted to have changes made and they didn't get a chance to change their will, they're unable to change their will. Okay, nobody can change their will on their behalf. Does an executor have to step in and execute the will when the first spouse in the estate dies? Or is it handled by the surviving person? So in a lot of cases, generally speaking, what I will say is that most people usually appoint their spouse to be their executor. If they don't appoint their spouse to be their executor, then yes, the executor would have to come in and do the estate of the deceased person. Yeah, that's normal. If the surviving spouse is mentally incapacitated, what has to be done? That is a really broad question and a really it depends question on what's already been done with the estate. Is the person in long-term care? Does the person have guardianship? A whole bunch of issues with that. And that's where things get really, really dangly. If I have a tax-free savings account in my name, and if I die, will my husband be able to access that account? If his name is not on it, not necessarily. I'm not sure if tax-free savings accounts have beneficiaries named to them. I really don't know. If they don't, then your husband would probably have to do what's called, he'd probably have to apply for probate in order to get access to that tax-free savings account. In your land transfer, I don't think you could stipulate what happens to the land once it's willed to the person. The will, that person becomes the owner and they can do what they want with the land. In other words, once it's willed to that person, it doesn't have to stay in the family. A new owner doesn't want to keep it in the family. Gary, I'm going to answer that question. So you can stipulate your wishes. So in my example, they can stipulate, yes, I want this land to stay in the family. I don't. If I get that piece of land and I decide I don't want to put it in, I don't want to keep it in the family, I can sell it. Up to me. Don't care. But that's not what I want to do, right? Like, that's the conversations that you have with people while you're still alive. So you can certainly put it in your wishes in your will that, hey, I'm giving this person this land and I want it to stay in the family. You can say that. Whether they're going to follow it or not, that's not something that you can actually control, unfortunately. Copy of slides available after session? Yes. Yeah, well, I'll send them out. I'll send them to Sharon. She'll send them out to you all. Oh, thank you, Connie. Normally, what is the cost of probate? So probate is, depends on how much you have in your estate. Okay, so it is, hold on, $60 for the first $1,000 and then 60 cents on every 100 after that. It's good math. There is a probate calculator to fill it out for the court fees. It's not unreasonable. Can your executor be one of your witnesses? No, they do not. They're not allowed to be. So your witnesses have to be over the age of 19 and they're not allowed to benefit from your will. And your executor does kind of benefit from your will. So your executor is not allowed to be your will and they're not allowed to be related to your beneficiaries. So for example, my husband is not allowed to witness my parents' wills. Is every will probated? No, not every will is probated, but if you're dealing with real property, so you're dealing with land, yes, it has to be probated. A lot of bank accounts now, when you're dealing with things like, RSPs, those types of things, banks are actually really cracking down on wanting to see letters of probate before they give you access to any types of bank accounts at all. Can an executor cash in common shares when there is no beneficiary? Any charge by share company? So if there is common shares and there's no beneficiary named, those common shares would be cashed in as part of the estate. And any charge by a share company, I guess it depends on the share company, whether it's going to be charged or not. Can I give an overview of a trust versus a will? No, can't. I'm not a money person. I am not a money person at all, so I can't. A will deals with everything, not just the money. Trust deals with money. That's my biggest overview on that. In my guide for executors, dealing with any assets of the state, once you begin the process, you're legally bound to complete the job. In my guide for executors and administrators, it says the following in relation to decision to accept the responsibilities of executor. Prior to dealing with any assets, you have the option of refusing. Once you begin the process of dealing with the estate, you are legally bound to complete the job. If you change your mind after you begin the process, you will have to apply to the court to be relieved of your duty. What does legally bound to complete the job means? It means that you are required by law to complete your duties as executor. If you decide that you can't, you'll have to ask the court to say, hey, I can't do this anymore and I need somebody else to take over. That's what that means. They're not going to arrest you though, but there could be monetary fines. Can we please have Sarah's picture back? I am so sorry. I took off my video because the internet's really unstable tonight. What about existing wills at a lawyer's office? Can I take that will and make changes without that law firm and make the new will? Yeah. So yes, you can take your old will and make changes to it or make a new will, and that will void the old one, provided you get appropriate witnesses. Yep. So somebody asked, they had wills, power of attorney, advanced healthcare directives prepared when they were common law. They're now married. Should they have new documents prepared? The will 100% needs to be redone. Yeah, your will definitely has to be redone. What is the purpose of estate planning if a will has all the details? So estate planning is not just about the will. The will is going to be what happens after I die. You'd want to know, like, what are my wishes for funeral? That's really important as well. So there's a whole bunch of other things too, and we'll get into 2 more things when it comes to a whole bunch of other things here. TSFA, best to ensure your bank is aware of your wishes and have beneficiaries' names. Yeah. So you want to make sure you have beneficiaries named on things like RRSPs, pensions. Those are the 2 things that I can think of. Tax-free savings accounts, yes, you can have beneficiaries named. It's not necessarily to include that info in the will because anything that has a named beneficiary in it doesn't become part of your estate. Okay, so my life insurance that has a named beneficiary, that's not part of my estate. That named beneficiary gets that benefit. At what point or level of dementia is deemed to be legal incapacity? Very subjective. So who decides? Harley, that is a question that we are trying to figure out. When I worked in private practice, we would always just talk to the person. You know, hey, Ms. Jones, why are you here today? I needs to write my will, or I needs to get my affairs in order is the most common answer we would get. And we'd be like, okay, so what does that mean? So we just talk to them, right? And once you determine that they know what they wanted, that they needed to write a will and that they knew what they owned and what they wanted to give it to, that's kind of how we did it. There has been times where, you know, I would be sitting in on these meetings with a lawyer and we would look at each other afterwards and say, not today. They don't understand what they're doing. So it is very subjective, and it's something that is a struggle in the legal community. I will be quite honest with that.
Sarah, can I just
Yeah.
jump in? This is Sharon.
Yeah.
I just want to let the audience know that there's some law reform actions, I think, beginning to happen, and it comes down to the right to decide. And
So
yeah, right.
we
And
are on a working committee for that.
okay,
That's why I said it's a
yeah, and so you know the 2 opposing things are mental capacity and legal capacity, and they're 2 different things. So it's really hard to answer that question. I appreciate how awkward that is for sure, because every case, as you said, it is different. Yeah.
It is very difficult. And yes, we are on a working committee. Thank you for bringing that up. I wasn't sure how much I could divulge on that yet.
Well, I'm involved in it too, so.
Very good. Very good. Yeah. So yeah, stay tuned, I guess is the best word for that. can a man and wife have a joint will, or do they have to have two separate wills? So there's no such thing as joint wills. That's not valid. If somebody says you can do one, they are wrong. It has to be two separate wills. What I will say about that is that my will and my husband's will are identical, except I'm his executor, he's my executor, but everything else is the same. So it's called it's called a mirror will. So they have to be two separate wills, but they can be very, very similar if you want them. Can your children be your executor? Yes, absolutely. Who decides whether a will is to be probated? Well, there's laws around that. Like I said, if you're dealing with property, absolutely. Some banks will require it. Some pension plans require probate if there's no named beneficiary. So I can't say who decides. It's an it depends question. Does PLIAN offer samples of wills to follow? Maybe. Stay tuned. Please explain about probate. So probate is a legal process. It's a court process where you file the will with the court and they look at it and make sure that it is valid. And you get what's called letters of probate, which basically means, yeah, will is valid, all good. Executor promise that they're going to do the best thing that they can. I'm not going to get too much into that, Edward, because I have a whole other session on probate and how that works. And it can be, it's not difficult, but it is a little bit of time, and we don't really have time tonight to get into the full ins and outs of probate. If it's just myself and my daughter, would the will have to be probate? Again, it's an it depends question. Depends on if you have land or not. When you are co-tenant on a piece of land, can you give your part to your adult children, keeping in mind the other is co and has okay. When you are co-tenant of a piece of land, can you give your part to your adult children, keeping in mind the other co-joint has a precedent beginning over his part, which I agree to? Do I need his kids' permission to give my share to the kids? I'm not really sure I understand that question, Maureen. Your executor can't be your witness. So an executor cannot be a witness to the will. So usually when you're a joint tenant or co-tenant on a piece of land, when you die, the other tenant gets that land. That's normally what happens. A handwritten will, a handwritten will only needs one witness, correct? Incorrect. A handwritten will, so I write it out in ink by my own hand, doesn't need to be witnessed. However, the best practice is to still get it witnessed. Okay, so it doesn't have to be witnessed, but the recommendation is to actually have that witnessed. Because what I have seen and what we have seen in courts is that people are saying, oh, that's not mom's signature. Mom didn't write that. So it's really good to have two witnesses there, because then the two witnesses could come into court and say, yeah, I saw her sign her name. I understood that from my financial advisor that my legal spouse was automatically the beneficiary of my RSP TSFA. No, that is not true. There is no tax implications or inheritance tax here in Newfoundland and Labrador, or in Canada, I mean. So yeah, no, your legal spouse is not automatically the beneficiary of your RSP or TSFA. If you wanted to leave them to children, there's no tax implications for them if they are named beneficiaries, because it's considered inheritance. Can I comment on codicil? So codicil is a change to your will. Can I yeah, codicil is a change to a will. So back when I first started, wills were still being typed up on typewriter. And I know that sounds really odd, but yes, wills were still typed up on typewriters. So a codicil would be a change. So I wanted to make a change to my will, and I don't need to change my entire will. So in order to do a codicil, you would say, this is a date, I'm making a change to my will, here is what I want changed. It still has to be signed by 2 people. It still has to be witnessed by 2 people, and it has to be signed by you and dated. They're not, codicils aren't as common now because with the advent of computers and how fast it is to change, it's just as easy to print off a brand new will and destroy the old one. But yes, you can still do a codicil if need be, but they're just not as common anymore. If someone is common law, they're entitled to death benefits or survivor benefits from work pension. No, not necessarily, Leslie. They are entitled to the Canadian pension plan, potentially. But they're not recognized here in Newfoundland. So, I mean, that's something you're going to have to check with your pension people to make sure that they are entitled to death benefits, because we've seen, and I've had calls of people who thought they were entitled to death benefits as common law and they weren't. How can you validate a signature on a holographic will? So that's a will that is written by hand. You'd have to get people who knew you to come in and say, hey, that's their writing. Do you need, does one have to do a new will if the witnesses die before me? Nope. Do you need copies of your will or just the original? Just the original. The original is the most important one. If you do not have the original will, we can't do anything with it in the courts. Okay. All excellent questions. Just for, if you have real property, which yes, real property. If you have land, your will has to be probated. Real property is land, it has to be probated. So you sell land, has to be probated. That's, yeah. Okay. All right, moving on. Yeah, check with your financial advisor. Yes, check with your financial advisor. But yeah, you can also name children as beneficiaries. There's no tax implications on it. So enduring powers of attorney. So considerations. So you're going to follow the rules of the Enduring Powers of Attorney Act. Again, you have to have legal capacity to create it. So I understand that I want to have an enduring power of attorney, and I know who I'm naming, and I know the implications of it. Now, that doesn't mean you have to read it and understand every single bit of legal wording in it. If there is legal wording, it's basically, I understand, I want somebody to take care of my finances when I can't. So your enduring power of attorney, it has to be signed by me, the person who's making the document, as well as one independent witness. That independent witness over the age of 19 who is not going to benefit from this power of attorney. This comes into effect upon incapacitation. So all of a sudden, I don't understand how to deal with my finances anymore. That's when this comes into effect. You can actually put in this enduring power of attorney. So this endures beyond my understanding. A normal power of attorney, I still understand everything about my finances. I know what it means. I know what I'm doing. I know everything about it. I still get some say. It's just I'm not actually dealing with my finances. The enduring power of attorney endures beyond that. So all of a sudden I've lost my understanding. So now this enduring power of attorney comes into effect and into play. You can put in this enduring power of attorney, I want it to come into effect on a doctor stating, or a mental health professional, or somebody stating that I'm unable to make financial decisions by myself. And it can be revoked once I gain that capacity back. So who can act? Anybody who's over the age of 19. Okay. You want to make sure the person you pick is somebody you trust. You can place restrictions on your property. You can state, do not sell my home because it's in my will. Other than that, they can do pretty much anything. They are using your money to spend on you. Okay, really important. They are required to use your funds to spend on you and you only, and that's it. Best practice and really important, require that power of attorney to make financial reports to other family members or to your children so that they know that your power of attorney is doing everything above board and they're not taking the money and flying off somewhere with it. Some considerations: if you own a business, what's going to happen with that? If you need to sell a house, who's going to sign the agreement? And who's going to act as your backup attorney? So always good to appoint an alternate as well. So why have one? This is insurance for when you are in need. So all of a sudden I am unable to make financial decisions and I still have bills I need to pay. But nobody can access my bank account. So this enduring power of attorney is going to come into play. You bring it to the bank and they'll be able to, help you out with that. It takes a lot of stress off of family and loved ones, and it prevents family fights and legal bills. Okay. Your appointed attorney, they have to act in good faith to protect your best interests. So they can't spend your money for their gain. They have to pay your taxes, your bills, all of those things. They can do pretty much anything with your estate, and they can also hire professionals to help manage your affairs, like an accountant. But you may want to consider, are they going to use that accountant out of your money, or are they going to pay for the accountant out of their own money? So it's going to give you the ability to help somebody for someone to help you during your times of need, so moments of immobility. It's going to allow somebody to access your financial affairs when you're not able to. So for example, you're in a coma, or you have Alzheimer's, or you need extra help because you just don't understand it anymore. And it allows you to choose the person who will help you in times of need and how your finances are handled. It's not a will. So your power of attorney, as soon as you pass away, your power of attorney is null and void. Okay. They can't act for you once you've passed, except under very specific circumstances. So for example, you were selling your home and then you passed, they can continue on with that sale. But they do not give, power of attorney gives no right to do anything under the state of a person. It is not a document that gives powers like a will. So if you don't have one, somebody's going to have to be appointed to take care of your money. So it's through guardianship. It's very expensive. There's a lot of forms, and there's no guarantee that somebody is going to come forward to do guardianship for you. There's two types. One is of the person. So that would be the social and medical decisions. And the other one is financial decisions. So guardianship of the estate is a court-ordered power of attorney. That's pretty much what it is. It only gives powers to pay your bills, file your taxes, collect your checks. It does not concern medical social decisions. Okay. So guardians, they're appointed by the court. They have to live here. So if I have an enduring power of attorney, they can be anyone, anywhere, outside of Newfoundland and Labrador, inside of Newfoundland and Labrador, outside of Canada, who cares? They can be anybody. A guardian has to be living here in Newfoundland and Labrador. They have to act in good faith, just like my power of attorney. And it can be revoked by court application. So I can certainly, somebody can say, hey, that guardian is not doing what they're supposed to be doing with mom's money, so I need to take them to court and get them revoked. If there's no guardian or no power of attorney, you might be okay, but you're not going to have anybody to handle your finances. So nobody's going to file your taxes. Nobody's going to pay your bills. I don't know what's going to happen. Also, if there's no guardian or no power of attorney, it's an opportunity for somebody to abuse mom and dad. Somebody could get into their bank accounts, scamming, collecting their pension or their CPP and then cashing it. Guardians and powers of attorney are supposed to prevent this from happening and are supposed to pursue anyone who is stealing from you. So, any questions on that quick overview? Okay, still probate questions. Probate, who does the probating? The executor will probate the will. Probate fee applies to all of the assets. You had a will done in Nova Scotia. Will this be a problem? I don't think it will be, William, only because Nova Scotia's laws and our laws are very similar. So take a look at the will. If the will was dated, the will has an executor appointed, and your will was witnessed by 2 people over the age of 19, your will should be okay here in Newfoundland. If a home is willed to someone, does that include all personal belongings in the will? No, it doesn't, Randy. It just the actual building. If you will your home to somebody in the future, and in the future the couple split, how can you ensure the home is not split between them? Geraldine, you can't. You can't, because it's theirs now. And if it's, and it would be considered, let me put a pin on that. So if you will your home to somebody, so say I now have my parents' house and my husband and I split up, that could be considered matrimonial property, and I'd have to make a case to the court that it's not. So it's not something that you would have to insure. It'd be something that I'd have to insure as the person who owns that home. When do you probate the will? Again, when it's needed. Does a power of attorney need to be completed by a lawyer? No, it does not. There are samples in our legal planning guide of a power of attorney. And again, it only needs to be witnessed by somebody over the age of 19 who is not going to benefit from your power of attorney. Can there be a guardian and a power of attorney? No, there can't. A guardian would be if there is no enduring power of attorney appointed, and it is a bit expensive. You wouldn't want to have a power of attorney and a guardian because it's just too much work to get a guardian done. If a power of attorney has been appointed, can a guardian be appointed after the fact? If the power of attorney is not doing what they're supposed to do, and then nobody else steps up, then yeah, you would have to go to court and apply for guardianship of the estate. Are the NL forms for power of attorney and healthcare directive okay to do without an attorney? Yes, they are. They just got to be witnessed by somebody over the age of 19 who's independent. All excellent questions. Okay, Advanced Health Care Directives. So this is a document that allows an individual to give instructions about future medical care and their designate and designate an individual to make healthcare decisions when I'm not able to. This document comes into effect and only remains into effect when I don't have capacity or I'm unable to communicate my healthcare decisions. Sorry. If a substitute decision maker is not appointed, the Advanced Health Care Directives Act sets out who will be asked to act as the substitute decision maker. The rest of the directive will remain valid. So if I don't appoint a substitute decision maker, then there's a list of who will be able to make healthcare decisions on my behalf. That goes married spouse, then children get an equal say. So it's married spouse gets the choice first. If no spouse, no married spouse, then the children would have to come to a consensus. If no children, then siblings. If no siblings, then parents, etc. So what this means is that common law partners do not have a say unless you have your Advanced Health Care Directive and you appoint them as your substitute decision maker. If there are members of a family that an individual doesn't want to act as their substitute decision maker, you can specify that. So you can say, I don't want John to be my substitute decision maker. That's perfectly okay to say as well. So requirements found in the Advanced Health Care Directives Act. You have to be 16 years of age or older for this one. I have to have capacity. I know why I want to do an advanced healthcare directive. So I know I want to appoint somebody to make my healthcare decisions for me. This document has to be in writing. Again, all of our documents are written. They're not allowed to be on the cloud. They have to be, piece of paper in front of me. Signed by me, the person who's making the directive, and my substitute decision maker. So this is the only one that the person I appoint has to read and has to understand and agree to it and sign that they agree to it, as well as 2 independent witnesses. Those 2 independent witnesses, again, over the age of 19, not going to benefit from your advanced healthcare directive. You're a substitute decision maker, so they're going to communicate your instructions that are in the directive to your healthcare professionals, and when necessary, they're going to make healthcare decisions on your behalf. Your instructions are going to provide guidance to the substitute decision maker. So it can be general principles regarding your health and what you want the substitute decision maker to keep in mind while making healthcare decisions. I don't know the ins and outs of all of this healthcare stuff. Yes, I'm a first responder, but I don't know a whole lot about the end of life care or the implications of comfort care versus palliative care. I don't know. I just don't know. So just be aware of that. You can be very broad with this too. You could say, I want my substitute decision maker to make all decisions on my behalf. I know what they know what I want. Or you could be very specific. So very specific would be, if I have X diagnosis, so say I have, I don't know, a stroke and I'm unable to walk, talk, eat, I don't want any more interventions. So you can be very specific. Or very broad. I would suggest talking to a healthcare provider about advanced healthcare directives, because they would have more knowledge than what I would do or what I would have on the actual ins and outs of what interventions are and what can be considered interventions. When do they not apply? They don't apply in emergency treatments. So treatments that are made in emergencies to preserve life, or where delays in contacting the decision maker can cause additional harm. So if you're in the emergency room, they're not going to be looking for your advanced healthcare directive. They're going to keep it going until they can get in touch with your substitute decision maker. And then involuntary psychiatric treatments. If you are detained under the Mental Health Act or any other act, to the psychiatric facilities for treatment, this advanced healthcare directive is not going to apply. However, you will have an advocate appointed on your behalf. So let me see if there's any other questions. If a fee is applied to probating a will, it should be done when the executor determines the final value of the estate, correct? Yes. So the probate fee is based on the final value of the estate, which is the assets, okay? Not the debt. So it's the assets minus the debt, I should say. So whatever's left. Scenario, husband and wife, no kids. What happens when one dies and there's no will? Surviving partner automatically inherits all. Yes. Is there a will needed? I always recommend a will. Always. I will always recommend a will. If someone is named as will, if someone is named in the will, okay. So there's 3 different documents, Leslie. There is your will, which deals with after death. There is your enduring power of attorney, which deals with I'm alive but can't deal with my finances. And then there's the Advanced Healthcare Directive. The Advanced Healthcare Directive is the one that my substitute decision maker, so the person that is going to make healthcare decisions on my behalf, they're the one that's going to have to sign. Thank you. Oh, you're welcome, Cecil. So I'm just seeing if there's any more questions in the chat. I'm going to stop sharing my screen. Question, how do I resign from being an executor? It's a court form. Yeah, it would be a court form. So you just apply to the court. So I will say this is a lot of information in a short amount of time. Okay, it can be information overload. So what I'm going to do is I'm going to send my slide deck as well as my legal planning guide, which has some really good examples in it. If you have any questions afterwards, my contact information will be in that. You can certainly contact me and I will be able to answer any questions that you may have. And there's still some more questions, so I'm going to quick answer those. Certified copy of the will, no, that is not valid. If you only have a certified copy of your will, you're going to have to get a new will done up. And can I repeat 3 areas? You need a will. What am I going to do after death? What do I want done with my stuff? An enduring power of attorney. Who's going to take care of my finances when I'm alive and I'm unable to? And the Advanced Health Care Directive. Who's going to make healthcare decisions on my behalf? That's everything in this presentation. I'm sure there are more things we can discuss, but I only have a certain amount of time. So thank you, everyone.
Sarah, I want to thank you very much. I've just posted the address where the slide deck will be posted. It's on the Pensioners Association website. It's www.nlpspa.ca. But you have to give us a day or so to get this all put together and get the recording completed and so on. And for Sarah to get the material to me. So in the meantime, Sarah, on behalf of everybody, thank you very much for your time this evening. It was a lot of information, and I see that folks were very interested because of the volume and the content in the questions that were actually asked. So I want to thank you for taking that time, and I want to thank everybody else who's on the meeting tonight for your interest in this. And I want to sort of say to you, stay tuned. We'll offer whatever other information sessions that we can arrange. And I think, Sarah, did I hear you say that you were actually doing a session or preparing a session on probate? And
Yeah,
maybe...
so we're doing an executor's information session. I think it's in April with the AC Hunter Library. So if you go on to the AC Hunter Library, you'll be able to see what sessions they have. So yeah, definitely. I think that one's in April.
Okay, and
yeah, and anytime anybody
yeah.
wants presentations or whatever, certainly welcome to reach out to me if you wanted me to come out to your area. If you don't live in St. John's, certainly that can be arranged as well.
Okay. All right. Well, I want to thank everybody for your time tonight, especially you, Sarah. And I just want everybody to enjoy the rest of your evening and be safe. Thank you so much.
You're welcome, everybody. Have a good night.
Yeah.
Sarah, I have
Good
a
night.
question. Sarah, I have a question, the last one. Can I ask a question? Do you have time?
Sarah,
one
are you
quick
able to ask a question from Rami?
Yeah,
Can-
just one quick question. When you
Okay.
say Sarah, you say you can make a presentation to a group. Just
Yes.
invite me on it. Do you have to have a certain size of the group?
No, not at all.
Okay.
I'm gonna put my email in this chat. So if anybody has any questions or want to follow up, please reach out to me. But yeah, no, it doesn't have to be a minimum or a maximum amount of people.
Thank you.
We had 177 on tonight, so that's a great crowd, Rami.
That's wonderful. I think that's the biggest one I've done.
That's awesome, Sarah. Thank you. And
You
if
did a great,
anybody,
excellent job.
and if you have misplaced Sarah's email or you want the info, the contact phone numbers, just send us an email at the pensioner's office and we can get all that information for you. Okay? So with that, I'll say good night, everyone, and enjoy the rest of your evening. Stay safe.